Okay, so there's a reason why I am correctly the last person on the panel. You've just heard from a bunch of people who have written and thought and spoken deeply about originalism, whether or not they are originalists. I am not such a person. When I got the call to participate in this panel, I asked myself, and I in fact asked the organizers, why me? I am not a Federalist or a fellow traveler of Federalists. I have not engaged at all with originalism. I have not said word one on the subject. I'm not even doing that much constitutional law as a percentage of my academic docket anymore. I think a glance at your program will give you the principal reason why I was invited. I am the only girl with a speaking part in this symposium. There are a few distinguished female moderators who are associated with the Federalist Society, but you ought to realize that, however much diversity might be a desideratum on any other panel on any other subject, subject of the proper role of the federal courts, if you will, there really does need to be a girl represented if the topic is originalism. Because whether you are looking at the original Constitution, or you're looking at the post-Civil War amendments, both procedurally and substantively, women are left out. And you do not have to be, as I am, a feminist theorist to see that, right? So if you look at the original Constitution, you may, I'm sure, you're sure I'm familiar with Abigail Adams' famous letter, Remember the Ladies, in which she says, I'm glad you've declared an independency, but I desire that you would remember the ladies and be more generous and favorable to them than your ancestors. Do not put such unlimited power into the hands of the husbands, etc., etc. Well, of course, the response, and I think this was both the specific intent of the framers, the general understanding of the ratifiers, however you want to talk about the process by which the original Constitution came to be, the intent was that the ladies not be remembered. They weren't just passed over, they were specifically left out. What John Adams responded was, first of all, I cannot but laugh as to your extraordinary code of laws. But then he went on to say, depend on it, we know better than to repeal our masculine systems. Although they are in full force, they are little more than theory. We dare not exert our power to its full latitude. We have only the name of masters, and rather than give this up, which completely subject us to the despotism of the petticoat, I hope General Washington and all our brave heroes would fight. Now, you could look at that as a principled decision about the allocation of power and the locus at which power is exercised, in the same way as you might the construction of the Senate, for example, or separation of powers. And this notion that petticoat, that women had so much power in the home that they couldn't be afforded any power in the state, in the contemporaneous French Revolution, involved legislators taking away from women voting rights that they had held since the Estates General of Philip the Fair in the 14th century. And again, not just accidentally, not because they didn't notice them, but on purpose. That was part of the original intent. You go to the Civil War amendments, and the same kinds of things happened. People like Ward Farnsworth and Lee Vandervelde have written very well, and I urge you to look at what they've written about the debates at the time of the ratification of the amendments concerning whether the other domestic relations, the relations of parents to children, including their daughters, or fathers in particular to children, and in particular the relations of husbands to wives, would be upset by the passage of these amendments. So, you can heroically, as Michael McConnell has done, reconstruct Brown on original grounds. Even if you can't do that, you can find all kinds of things like potentially affirmative action in the post-Civil War amendments for black people. You can't find anything good for women. You really can't. They were kept off juries, off voting, and the very masculine despotism that Adams endorsed was reinforced. I think it is therefore not surprising that in the line of cases that are current constitutional sex discrimination law, original intent was completely repudiated, and indeed in Franchero what the court says is the position of women in the post-Civil War codes was very much like that of slaves. I think that's indisputable. And the question I have, one of the questions I then have for originalists is, you know, defend Brown or not, do you also defend Franchero and its progeny? And if so, how? And if not, is there a constitutional break to returning to coverture, for example, as described by Justice Bradley in Bradwell? I mean, I'm sitting here, you know, a free single woman, a lawyer, a professor, in ways that original intent, or an original understanding, an original meaning, whatever words you want to use, would not guarantee me with liberty and equality that case law and not any version of originalism is granted me. I want to come back to this in a few moments. I want to, though, address briefly the question presented, which gets to is originalism a principled method of interpretation? And I want to associate myself with Richard Fallon's remarks, especially to the extent where he says, you know, it can or can't be a principal method of interpretation. Whether it can be doesn't mean it is, and whether it is doesn't mean it should be. And I want to illustrate them with an example that I beseech you to take seriously and not fliply. Actually, I have two examples. One you're going to think is flip. It's not. And I introduced this example by saying, you know, several decades ago when I was a practicing lawyer in New York, I was in a reading group with a bunch of people, some of whom are well known to you. One of them was Deborah Livingston, now a judge on the Second Circuit. She's not the one I want to talk to you about. Another member of this reading group was a professional astrologist. And she would try her best, whatever book we were reading, to chart the characters. And she was a very serious and, if you will, principled astrologist. But there was not usually enough information in the books to give you enough to chart the characters in a way to get a determinate principled result. That's, you know, mutatis mutandis, also a problem with originalism. But I want to pursue the astrology analogy in a couple of other different ways. I think we're not engaging in principled originalism any more than people are engaging in principled astrology when they look not to a careful and specified charting of their and the signs of the people around them, but when they turn to the Daily News or the New York Post and they read a simple single little phrase that says, you know, here's your fortune for the day, and take it seriously. One of the things I tried to do in the very limited time I had to prepare for this talk is to try to educate myself as to what role originalism had actually played in Supreme Court cases. And I said, you know, can you point me to any kind of empirical work that looks systematically at U.S. Supreme Court cases in which originalist arguments could be employed to see if they are employed, and if so, by whom, how often they're outcome determinative? And the answer is no, nobody's done any such thing, even just as an empirical matter. And I think this, you know, undercuts the notion that originalism is being applied in any kind of principled fashion. And I would, you know, it's not clear that the ability to apply it makes any more sense than the ability to apply astrology in a principled fashion. Perhaps it can be done, but we don't do it, and maybe we're right not to.